Welcome. Another Wednesday. It's the Alberta Landlord Shoptalk show. I'm your host, MacKenzie Wilson. All things landlord in Alberta. Beside to me, to my left, which is my right for you guys, is Don Gray up in Edmonton, Alberta, from Edmonton Eviction Services. And Don, how are you doing this fine night?
Absolutely fantastic. Another wonderful day in paradise.
That's right. That's right. Are you watching any hockey right now?
I haven't had time.
Oh, fair enough then. I make time for playoff hockey because the Flames haven't been here for a while, so I'm happy to be watching it. And we're doing quite well. So we've got the hat on. I got a picture. It doesn't quite show up too well, but that's me and the kids sitting on the couch last night with Flame jerseys on. So quite enjoying it. So Chris is not going to be with us tonight. So Don's got some big shoes to fill. But I think we're going to put him through his paces. We've got some cases lined up tonight. Actual RTDRS hearings we'll go through because we are that cool. Dig through the details of these cases, learn a little things, how we can do be better at the business of landlording, and hopefully have some takeaways for everyone and learn the business a bit more. So maybe it's a good time. We'll kick off the little intro video. You got 30 seconds or so. Grab a drink, get comfortable. And when we come back, Don and I will start turning into some of these cases. Folks, if you've got questions, this is definitely the show to ask them. We're going to drive the content from our observations, but if you see something or you need clarification, please throw your comments in the show and we'll tie them in. And it is really about helping each other learn and be better at this business of landlording. So without further ado, let's kick the show off. Mr. Don. Hey, well, while I've got you, Don, what is the wait times these days right now at RTDRS if people were to file today?
3.5 to 4 weeks. We had one of the ones we put in today, I think was June the 3rd or something. Yeah.
Okay. Wow. So about a running month right now.
Yeah.
Hey, good to know, folks.
Sometimes they come a little quicker, and just in that.
Yeah. Okay.
And that's that's for normal evictions. Things like damage claims and stuff. That it's a couple of months down the road.
Okay. I do know if there's an emergency or if there's a threat to the premise, or if there's like a circumstance kind of that's a little bit worse, they'll expedite some of those cases. But generally, if it's the run-of-the-mill eviction that you're going for, you're looking at that time frame.
Yeah, if it's violence involved, damages, somebody getting hit or threatened, or actually something happened, we can get those off in less than a week.
Yeah. Okay. Well, that's good. That's good. Glad to hear that. So, folks, say hi. Let us know where you're tuning in from across this beautiful province of Alberta, and let's do some casework. We've got one question already, and I'm gonna have to do the job of what Chris does so very well. So let me get Facebook up and running so I can get the Facebook users a real name beside Facebook user. So give me a small second here. Do a few clicks as I get organized. Computer's a little bit slow. And then, got these cases. I'm kind of excited for this, Don. I'm going to pick your brain a bit because I'm going to learn a lot from you because this is not my area of expertise. And that's why I always enjoy these shows. So
I don't want to teach you too much. I won't have any work.
Oh, I'm sure there's always enough work to go around, especially in this business. Isn't that true? Okay. I don't know who that is. I can't see here. That's fine. We'll just we'll leave that. So let's I gotta mute this thing. There you go. Okay, I got it. Oh, Michelle. All right, awesome. Okay, so let's dig into the first case. I did do some highlight, and then the next one I didn't highlight was going to highlight with your input along the way. So I kind of compare and contrast if my uneducated opinion is somewhat relevant. So let's pop this up on the screen here. And Michelle, we'll take your question next. That's first in the queue. Hey, Teresa, coming in from California. Good to see you. We've got Rabi, you're saying hello from Edmonton. Welcome. And man, I gotta give Chris a lot of props. So we got Sharon from Red Deer, and oh man, I'm so bad at names. Florentine in as well. So welcome. Thanks for saying hi, guys. All right, so let's get into this first one here. So we have this case. The tenant is seeking an application to recover their damage deposit of $2,100, and then the landlord has also counter filed or sent an application seeking compensation for an overholding tenant for the amounts of $20,071. Sorry, $2,071. Damages of $366.95. And number 3, late fees totaling $800, less the security deposit for a total claim of $1,213.18 remaining. So, do you want to do the background facts, or how do you want to do this?
Sure,
Don?
whatever. I haven't had a chance to read them all very good.
Okay.
It's been a really busy day, but we will get through this as we go.
Well, let me run with this, and you get excited, you just jump in, and I'll give you the floor, and you add on, you riff on me. We'll build up the show here.
I'm excited all the time.
Love it. So October 1st, a lease is signed between the two parties. It's a lease of a fixed term for a year, starting November 1st, ending October 31st, the following year of 2021. Rent was $2,100 a month, and a security deposit was also provided of the same amount. A year later, so we've coming up to the end of this year's term, the parties made an oral agreement to continue the tenancy for an additional 6 months. There's no disputing this, as both the tenant and the landlord readily admitted this. They entered into an oral arrangement. The tenant then paid for November rent of $2,100. Perfect. So they're on 13 months now. So then the landlord follows up by sending a new written agreement to the tenant to do the extension. On November 5th, the tenant texts the landlord saying that they've decided against signing a new written agreement and that they would end their tenancy at the end of November. Okay. The landlord did not respond to the tenant's text message. He did not say to the tenant that he would be liable for any further rent or compensation if he moved out. The landlord remained silent. And this is, I'm just going to say this might be foreshadowing something here. And intended to rely on the contractual terms of the tenancy agreement. I know we always preach communication and set expectations on the show. So what's your take so far, Don, on this background that we've gone through so far?
Well, it's certainly setting up a very interesting situation where the tenant, 4 days after being told, he wanted their verbal agreement into a written agreement, and is now reneging. The fact that the landlord didn't reply is certainly something that we got to take note of, because the second one wasn't signed. So now he's in limbo. Is he overholding on the first one, or is he, if he's moved into now accepted money for this for the first month of the new term, he's now moving into a month-to-month or periodic tenancy, and that could bite him. So that's
so let's ask you a question on that, Don. I know we'll dive into some more. So if there's a verbal agreement for an extension of 6 months, but there's no lease in play or a lease never gets signed, what makes up the bones of the lease? Like, what are we relying on?
Well, the lease would still be the one that was from before, and of course governed by the RTA, Residential Tenancy Act. So whatever was in the original signed lease would still be in place. So things like no smoking or paying on the first or whatever, those things would all still be in place.
Okay.
Just now there's no end to it.
Right. Okay. Well, let's continue on. So the landlord's position. The landlord has a claim of $2,071.23 for an overholding tenant. He based his claim on Clause 18 of his tenancy agreement. Let's just dig into it. Basically, they say in the event of an overholding, the landlord should be, he's liable for rent on a pro rata per diem rate. So basically, is another pro rate on top of the rent he should also be paid for. So he's like doubling the rent almost for every day that tenant stays in.
Yeah.
So here's what the tenancy dispute officer said. Essentially, although the tenant paid the landlord the standard amount of rent, $2,100, the landlord is now claiming an additional daily rate for the days the tenant overstayed the original fixed term tenancy, allegedly overholding tenant. Given that both parties made it to me clear they've entered into an oral agreement to continue the tenancy for another 6 months, I asked the landlord why he was characterizing the tenant as overholding and claiming compensation on that basis. The landlord did not provide a satisfactory answer beyond remarking that if the oral agreement is enforced, he is entitled to an even larger award for loss of rental income. The landlord admitted that he received the tenant's text of November 5th indicating the tenant intended to vacate at the end of the month, but did not respond to the tenant and merely intended to apply the terms of the contract to lay claim to compensation for overholding and or loss of rental income. Yes. I shall continue. Okay. Anything you want to add on that? Or I guess we're just painting the picture right now.
Yeah. It's just the adjudicator is alluding to the fact that you can't have your cake and eat it too. You got to choose which way you're going.
Totally. The landlords is kind of contradicting themselves because they're trying to charge this tenant as overholding, yet they have a verbal 6-month extension over the same period of time. So, yeah. Or in the same months here that we're talking about. Okay, tenant's position. The tenant offered two essential defenses. First, the tenant claimed Consumer Bill of Rights that gives everyone in Alberta 10 days to back out of any contract. He said that after he orally agreed to the new 6-month tenancy, the law allows him to back out of the agreement within 10 days without any consequence. I asked the tenant if he could refer me to the relevant section of the legislation that gives him this right. I love this part. He told me that I could Google it. Probably not the right answer. Yeah, you want to help them out, not make their job harder. So I believe the tenant was referring to the Consumer Protection Act. Some gibberish there. The second defense offered by the tenant is that when he told the landlord on November 5th he would be moving out at the end of the month, the landlord did not respond. The tenant took this as meaning the landlord accepted the tenancy would end and there would be no further liability to the landlord. Interesting. So that's why it's so important for communication here. Okay, so this is kind of interesting too. Basically, the tenancy implied that referring to the Consumer Protection Act legislation allows a consumer to cancel a direct sales contract or timeshare contract within 10 days after receiving a copy of the written statement. The Consumer Protection Act has no bearing on residential tenancy agreements, so it's irrelevant. Okay, perfect. So we'll just kind of continue on here. Okay, overhead. So we're talking about. Okay, so I'll read this part too because we do need to kind of characterize this. And if people are asking me questions, I have not seen any. Okay, we got a question right here too. Let me just take a look. Wait. So, do we have to write what the overholding penalty is into your lease, and what is common? Doubling the rent for overholding. Don, I'm actually going to throw this question.
There is no. There's nothing in the RTA that offers a penalty. So overholding is when it's supposed to be out, they didn't leave, they're continuing on. Then you're going to court asking for possession because the tenant is overholding his lease. So that's where it is. So there's no overholding penalty written into the act at all. In fact, it's even frowned upon. What happens is if your tenant is moving into an overholding position, do not accept any more rent. So that's making it clear that you don't want them there. And then when you take it to court, the penalty, I guess, would be that the tenant would have to pay the landlord for the time that he was there until the time the landlord got possession. So you got to make it very clear if you want your possession of your unit that you want it. Now, Section 15 of the RTA says that it's very clear. It says that neither party has to give the other party notice. Now, I think it's pertinent from a business point of view that you give a tenant that you want it to end, you give them a month's notice or 3 weeks or something. And after you get your rent, maybe you say, your lease ends. I expect to do a move out inspection on the 31st at noon, and then they have some time. As a tenant, I would take the fact that the landlord hasn't said anything about renewing the contract as a clue, and to either talk to him or find another place.
Mm-hmm. Okay, good information. Perfect. Let's continue on. All right, pop this back in here. Okay, so really, like, we can write whatever we want into contracts and into our leases, but really these kind of fees have no weight in the Residential Tenancy Act.
No. If you collect them, great, you've made some money. But if it goes to court, you won't get anything.
Yeah. So I'm going to play devil's advocate here, Don. If you go to court, and that's the key thing. So what happens if we don't go to court? If we have these financial motivators, is what I'll call them, weaving into our document, and there's probably something to be said that they have to be reasonable. I think $100 a day is really aggressive, but if you had a $20 fee or something of that nature, saying that if you're late for rent, it's a $20 or $10 fee for every day you're late. You can't. Again, we know we can't charge them that going through the course, but we don't usually. What am I trying to say? I guess I'm trying to say is the odds are we don't usually go to the court. Usually go to that last step of going to the courts or RTDRS, but as a motivator, they still have a little bit of value in paper for the average tenant who probably doesn't know the ins and outs of the RTA. Well,
the RTA doesn't forbid penalties for late payment. In fact, it's totally legal to charge late fees and to collect them, but the court doesn't. It sees them as punitive damages or due to punitive costs. So they're not in the business of collecting those things. Collect the rent, absolutely. They don't collect security deposit either. So sometimes you need to do your ledger in a way that shows that money is still there. And so if you
let me add on to, or I'll ask you another question then, Don. So I'm going to be kind of simple here. What does punitive mean?
It means that it's a penalty, a harsh penalty, and they don't give penalties. Same as if your car hits you and you get whiplash, punitive damages is your whiplash, and there's nothing
compensation. Sure. So there's a right way and a wrong way to probably write these into our lease, and if we had to go through a hearing, we may or may not get awarded based on exactly how some of these fees are written up into our ledger.
Yeah. So one thing you can do, one thing you can collect is administration fees. So if you have a reasonable administration fee, $5-10 or something, $15-20, I don't know, maybe even $25. because the tenant paid late. Now you have to pay your accountant to pencil that in, and now there's a charge for that, and that's an administration fee. So I've seen those go through most of the time. Some of the adjudicators say, no, that's I know what that is. I'm not allowing that.
Okay. So let's kind of a pro tip here, everyone. I'm going to recap what Don just said, but I love this in the sense that it's how you document the fees, probably in a way that shows that there's a reasonable cause for them and that you're not attacking or going after the tenant for more money because of bad behavior, but more so, listen, this is a cause and effect. You've delayed paying me rent. Now I've got additional costs of doing business by hiring a bookkeeper to do more entries and reconciliation and so on and so forth.
Yep, it's a cost to you, and you're reimbursing yourself for that cost, not a penalty. It's
cost reimbursement.
Money, so you want the tenant to pay that money.
Okay, so don't use the word
NSF, an NSF fee. Yeah, that's a cost to you, $5, $10, whatever it is. That's what you can charge. I mean, you can put in there that you're going to charge $50 and only pay $5, but if it goes to the court, the judge would say, okay, show me the invoice that you were charged $50.
Yeah, well, I want to see that. They'll probably just award you exactly what you were paid out of pocket, nothing more.
Yeah, that's right.
Yeah. Okay. All right. This is good. This is good stuff. I like this. Perfect. Okay. So continuing on. All right. Okay. So yes. Okay. We're talking about the overholding clause, which.
We got down to the tenant's position, and we got into governing legislation, and he's saying that the Consumer Protection Act has no bearing, but what has bearing in the next paragraph is the Residential Tenancy Act, and which does not provide for a 10-day cooling off period. So essentially, that defense is gone.
Yeah. So we went through that one. So the next part here then is talking about the overholding part. And he says a contractual provision such as Clause 18, this is a custom clause of this specific landlord's lease, is unenforceable if it sets the damages which are, quote, a grossly excessive and punitive, there's that word again, Don, I'm learning things tonight with you, response to the problem to which it was addressed, and disproportionate and unreasonable when compared with the damages sustained or which would be recoverable through action of the courts for breach of the covenant in question. So basically, I'm hearing is your fees are grossly out of the park. They're inaccurate. I'm not going to allow you to claim them.
Yeah, he's got it right and clear there. A double per diem would not be recoverable through court action or application merely for breaching the implied covenant to vacate the rental premises. So it's regular per diem, but not double per diem.
Oh, okay. So I'm going to put this in English to make sure I've understood you, because that's a lot of big words. So what we're saying is basically we can prorate the lease. If the tenant is overholding, they're supposed to be out on the 31st of October. They're moving on the 10th or say the 15th of November, halfway through. Then they prorate that month and only get charged half the rent because that's what they actually stayed for.
Yeah.
All right.
He's entitled to regular per diem, not double.
Okay. Yeah. So double. Yeah. Okay. So we can move on from that. Okay. Good.
Good.
Okay. In summary, I decline to award. So this is the counter application by the landlord for the fees. In summary, I decline to award compensation for an overholding tenant for 4 essential reasons. 1, the tenant was not overholding as there was a new oral agreement in place, right? 2, the landlord was paid full rent for every day the tenant occupied the premise. 3, the contractual provision for the double per diem is punitive and not enforceable. Okay, so it's crappy lease, doesn't count. Number 4, there is no evidence of any actual loss associated with a tenant staying for an additional month. So what would be the flip side, Don, in this situation if there was a loss? What would be an example of that?
Example for an additional loss? It would be rent. It would be the big thing if he left before the end of the month, or he hadn't paid, if he hadn't paid the month, then that would be a loss directly to the owner.
Okay. And let's say that this landlord was on top of his business and had another tenant lined up, and now that tenant can't move in. So is he losing that rent as well?
You can't double dip.
Okay, you can't double dip. But let's say that tenant says, well, you know what? It's the 5th or 6th of the month. I'm supposed to move in November. I can't get in the property because the previous tenant's still there. I'm canceling my lease. I'm walking elsewhere. And all of a sudden now, this landlord has a vacancy when he had it previously filled. How does that play out?
Well, now, did he get the rent from the former tenant? Is he paid for that month? If he isn't, right, then that would be a loss.
So let's say, again, same example, they move out middle of the month. The tenant is charged and has paid per rate up to when they moved out, but they've overhauled half of a month. The new tenant moving in has bailed because they're not going to wait around forever, and this landlord now has a unforeseen vacancy. Like, is that something that they could go after the existing tenant for because they had a oral agreement for an additional 6 months? Of course, he's got to put every reasonable effort into find to fill that vacancy, aka marketing and all that good stuff. But he just lost a tenant that was signed up because they couldn't move in, and they gave up and walked.
If the second tenant had gave him rent for that period, and the other tenant, the former tenant, didn't, and just occupied that space, then the second tenant or the new tenant would then be able to sue the landlord for not being able to have use of that property during that time. Yep. So then that would end up being a loss. Or if in another case, the second tenant was put into a hotel room and all the belongings put into storage. I've seen that happen. So now that is a direct cost to the landlord caused by the overholding tenant.
Right.
And so that's something you would ask for at the court.
Okay. Interesting.
And you have receipts to show it,
Yeah, you put up an Airbnb or a hotel for the tenant for a week. Well, with the open. Okay.
A week or a month,
cool,
or whatever. Yeah.
All right. Awesome. Let's just get down. We've kind of talked a lot about this one, so let me just kind of hit some more highlights here, and then I want to take Michelle's question that he posted up here. So we'll nail this one out quickly. Okay. Oh yeah. So this is okay. Where do I want to go from here? Okay, I'm going to paraphrase a bit and correct me if I'm wrong, Don. So jumping down here, we're kind of just going through the tenant dispute officer's result, or the what's the word I'm trying to say? The judgment he's come to, I guess. And the landlord encouraged the tenant to move out by abstaining from asserting his right to claim potential losses against the tenant if the tenant moved out after the tenant had vacated until. Oh man, I butchered that. What am I trying to say here? Okay, here we are. So I'll re-say this again. So earlier in this thing, the tenant did text the landlord, say, "Hey, I'm moving out." The landlord never responded, and he said, my view would be entirely different if the landlord simply responded to the tenant's November 5th text saying something like this: "I understand that you're moving out November 30th, but be advised that I will be holding you to the terms of our oral agreement for a 6-month tenancy, and you'll be liable to me for losses of rental income if I am unable to find a new tenant for December 1st. However, because the landlord remains silent, I find him stopped from enforcing his strict legal right to compensate for any loss of rental income." So if I'm reading this correctly, Don, the landlord knew he was in the right, but he didn't do proper communication to kind of try to fix or resolve the problem with the mistakes the tenant was making. And he basically the dispute officer is saying, I'm not going to allow him to enforce the strict legal right because he didn't He didn't manage the problem correctly. Is that kind of how I'm taking to it, or?
Well, yeah, he didn't tell the tenant what the repercussions of his decision could be or would be, and
Mhm.
that would have made it clear, and it made it clear to the adjudicator as well that this was where this was going. That he wanted to enforce his 6-month oral agreement, um, and then when he went to court, then he would have had a different view on it.
Right. Okay. So like again, the way the landlord handled the dispute was not good enough. They did not do the proper notifications. The didn't put the right effort in to mitigate risk on both parties, probably. Okay. So we got damages. The landlord's claiming $200 for labor associated with wall repairs. The tenant disputes this claim. The flows provided by the landlord do not convince me the walls were damaged beyond normal wear and tear. Therefore, I will not allow this amount, no amount for wall damage. Okay, so he's lost that. Claiming $166 for missing plastic bins and trash bins. Oh, right here. If a move-out inspection had been conducted with the tenant present, there would unlikely be any ambiguity regarding the whereabouts of these plastic bins. Therefore, I'm giving the tenant the benefit of the doubt and dismissing this claim. So what happened here, Don? How come this tenant or the landlord couldn't claim some of these damages because of this missing inspection?
If you go up 2 paragraphs, he explains it there. Section 19 of the RTA provides that a landlord must propose 2 alternative dates and times to conduct a move-out inspection with a tenant. The evidence suggests that the landlord conducted the move-out inspection without offering an opportunity to the tenant to be present. Therefore, the tenant is deprived of an opportunity to observe for himself the damage beyond normal wear and tear that the landlord claims exists. Tenant was deprived of an opportunity to document the alleged damage himself and offer his own evidence and their explanation for the alleged damage. So, therefore, in respect to the landlord's claims, the tenant must be given the benefit of the doubt. The landlord has a significant evidentiary hurdle to overcome. He has to prove. So, and that's what he's getting to in here. If they had done a move-out inspection as he should have, or even if he had offered him to in the 2 times and the tenant said stuff it up your nose, then he would have a leg to stand.
Yeah, thanks. Okay, gotcha. Yeah, it just went down the wrong windpipe. So, okay, perfect. So this landlord did do the move out, but because the opportunity wasn't provided correctly to the tenant, it's basically been negated. So good to know. So
it's very important.
Very important. So 2 different opportunities at 2 different times. Yeah. Okay. Cool.
And do it in writing. Email, text message, whatever, something that can be reproduced.
Perfect. Okay, there's some late charges. So I'm just going to kind of skip down to the gist of it. In this case, the occurrence of $100 fee, even when the rent was just 1 day late, does not obviously have any relation to the actual loss suffered by the landlord. Therefore, I find that the $100 fee is a penalty and in accordance to the common law, therefore unenforceable. Okay, awesome. So here's the final result. The landlord shall recover shall be awarded their damage deposit back of $2,100, and the landlord's application of all the above costs were kicked out. So, okay, that's case 1. Exciting. I know people are so excited right now. We've got a couple thumbs up on the show. Right on. Appreciate that.
Oh, good.
We're about actually a good handful of viewers right now. Okay, so let's take on Michelle's question here. All right, so Michelle's asking, how can I serve an RTDRS document to a tenant who's left the premises? Oh, this is up in your neck of the woods, Don.
Yeah, there's different ways. My favorite is to go on to Facebook or wherever and see if there's some clues somewhere as to where he went. Maybe finding a boyfriend or girlfriend or mother, father, or something like that. That can help with that. Often when people move, or what they're supposed to do is have their mail forwarded. So you could send it to your to the last known address, which of course is the rental unit, and that should be forwarded. If it isn't, then it'll come back and to you, and then you put that in the file. That's proof that you attempted. You can hire if you got good bucks, you can hire a private detective. Looking on the application form, should be next to kin or somebody that you would contact, or friends, something in there that you could phone them and find out, maybe find out some clues or some information. So email nowadays, email is allowed if you're if it's depending what kind of doc it is too. But if you want to serve them a notice of hearing, it's very important. If you've conversed with them by email, if you've maybe got paid by email transfer, then you can serve the notice of hearing by email. Once they're served with that, you can serve them additional information, additional evidence by email without even having a tracking system. So that trick on the email is that you have a way of tracking it. I have a program that I pay monthly for that lets me know every time they open that document.
Okay.
Tells me.
Yeah. Okay. I'm going to slow you down because I want to highlight. I think you gave three really good tips there, Don. Lots of nuggets there. So one you said was mail the document to the last known address, which is yourself. If they have forwarding in place, great. They've been served. They've got that through mail. But if they don't, and that mail comes back to you, you've created some evidence that you've put the effort to notify this tenant. So that's good. Number two is on the application, that little tidbit of that emergency contact. It's probably rarely ever used for the emergency contact, but definitely it's a very useful piece of information because it's usually a relative or close family member that you can follow up and say, hey, where's Johnny? I've got to serve him with this. This is what's going down. And what is your experience on that, Don? I know you've kind of gone down this path before. What's your response rate when you've used emergency contacts to track down someone? Has it been successful? Successful?
Yeah, parents are very successful. They tend to want to make their children accountable most of the time. And even with friends, relatives, people that know somebody close will know their faults as well, and
work with you.
Will help out. Yeah, or I have it even where they wouldn't give me any information, but they talked to the person and said, "You better call this guy. He's bugging me, and I don't want him to bug me. So you go talk to him and
solve your own problems."
Yeah.
Cool. Okay. Awesome. And then the third item, was email serving, especially if there's been regular communication or a precedent set with email. Mm-hmm. You're kind of now allowed to use that to serve documentation.
Yep.
Yeah,
perfect. That's right. You just have to be able to show that they opened it. So even most programs, email programs, have that where they check mark if that you've got it, and then they'll send you a red receipt. Yeah.
It sounds like this might be an opportunity for me to do a tech show on email software tracking. Mm-hmm. So I can probably figure that one out. It'll be pretty easy. I know I'm digging in my archives here because I remember one time you said, and it stuck in my mind, Don, that's why I still remember it, is depending on how your application is set up, you can run credit again with regards to that same tenancy. And so perhaps if it's 6 months later and they're gone and they've settled down somewhere else, what would be the value of running the credit again? How does that work?
Well, you can, if somebody else has run a credit check on them, and they will put the address in that they're doing a credit check for, and that will show up. Sometimes it'll show up their new place of work. You can serve them at work. So if you know where they work, take it there. If you find out they're working someplace, take a trip over and say, can I talk to Johnny? Say, let me get Johnny for you.
So when you run that new credit check on Equifax, you see registered addresses of where they're living and current employers. And so if you see a new entry in there's your tidbit that you can follow the trail forward. So fantastic. I love that. Okay, we're 20 minutes left on the show here. We went through a case, so I don't think I'll get to the third case, but the second case should be pretty quick. And I'm just going to follow up on everyone's comments here. Thanks, Christine. She says this is a good episode. I've actually found it really, really useful. I always do, again, like I get to pick your brain, Don. I try to stay on this side of the business because this usually means I didn't do something right up front on my due diligence, but it's good to learn how to mitigate these situations. And there are processes and solutions to doing that. So, okay. How about forwarding the address to on the DL? I'm not sure what the context on that is. That's
How about forwarding the address on the driver's license? Yeah, that may be a prior address. You could pull.
It's probably out of date, wouldn't it be? Well, I guess it depends.
You might be able to, if you probably could pull a what's it called there when you're going to registry.
Like a identification check.
No, there's another word for it. It's escaping me right now. It's if you're going to register a debt, you have to pull a. Yeah, I can't think of it. But anyway,
caveat or lien or something.
Yeah, it's not a lien, but it's a
tidbit for next show. Write that down. Okay,
3 a.m. it'll come to me. I'll wake up straight up in bed. It'll pop out of my mouth.
I'm just writing this down right now. I'll search this after the fact at the registry. Okay, so always send by registered mail with the signature required. I've had kids pick up the mail and the tenant had claimed they never received it. Oh, yeah, fantastic. Yeah, absolutely. We'll do a show on. I'll figure out something on email tracking. I'll probably throw it over on Alberta Landlordcommunity.ca in our private network. So if you're not there, check it out, folks. Okay. Stefan wrote, don't you need their permission to run another credit check? So should we explain this, Don, that we're just talking about?
When you do the application form, you have a bit on the bottom that by signing it, you allow them to do a credit check. And the credit check is just for the purposes of renting and related items. So that gives you the right to pull the credit check again.
And we should probably clarify what the connection is here. This is the same application on the same lease. Now there's money owing. We're going to pull another credit check in the future to try to track this individual down, still relating to that same application. And when you say it, if it's worded correctly with other items, that gives you that, I guess, precedence to be able to do that.
Yeah, the related items. Yeah.
Cool. Fantastic. Okay, Christian said we need more of these. You know what? I think we should hold off on the next case because I don't want to. I want to provide value and I want to skip over some of the parts. And we've got 15 minutes left.
Okay.
We're happy to take some questions right now, or maybe we'll wrap up the night a little bit early. But kind of just trying to do the case within the time we can accurately kind of go over the details without skipping some of the stuff, because there are so many nuances in that first one that landlord didn't really do right or correctly that they kind of got burnt, right? Yep. So, I mean, just a quick summary, they didn't have proper communication when the tenant was claiming incorrect recording, incorrect law, how they terminated the lease. They didn't make that effort to mitigate their risk or the liability. They just went kind of quiet on the texting there. So, and of course, some of the fees were pretty gross or punitive. I like that. I'm gonna have to do some more research on that, Don. Where the devil's in the details on how you structure these leases, going from admin fees or operating costs to $100 daily penalties or something like that, right? Where it depends on the author too, right? Some view it quite differently than others. Yeah. So okay.
Well, the thing is with the idea behind it is that you want the tenant to pay on time. You're not interested, or most people aren't interested in making those extra dollars. So there's a balance there. I have in my leases that there's a penalty. Very, very seldom do I charge one. They phone me, they communicate with me. I'm not interested in making that money. I just want the fair rent for my unit.
Yeah, same here. And I have one tenant that I get a text on the first within 15 minutes of them doing their e-transfer. They say, yeah, hey, MacKenzie, rent's been sent. Have a great day for May or whatever month it is. And then, I think I've had them now for 3 or 4 years. And I've probably have had 4 occasions or maybe 5, about 2 or 3 times a year, where they've gotten tight in cash and they say, hey, MacKenzie, I can send you X amount now. The remaining, $700, $500, $400, I'll send them my next paycheck 2 Fridays. I go, okay, sounds great. And what he said up front has been accurate and he's followed through. So I've got no problem doing that, because at the end of the day, I just want rent coming in, because then it's a good business. It works well when you've done your numbers right. So, okay. Let's take this one question here. I'm going to try to see who this is. Okay, so what about in a month-to-month lease if the tenant refuses to sign a new lease, new term lease, and they don't pay well? Okay,
you could be stuck. So the thing is, now you got to make it. You got to look at it from their point of view. You want them to sign a term lease. And then the idea being that at the end of the term, you're not going to renew because they're not a very good payer. So you want to get out of the month-to-month or periodic lease. And at least that's what I'm understanding the strategy to here. And so some of the things you can do is you got to make it good for them. So you can use things like, I'm going to give you a 3-month raise, rent increase of $100 a month. But if you want to sign a 3-month fixed term, I'll only make it $25. Because this is going to make my bank happy or whatever. You can use whatever excuse. And so that'd be one way. You got to know your tenant to some degree and what makes them tick. So what is it going to motivate them to go this way?
That's a huge caveat, Don.
Yeah.
I like that you brought that up, because we've talked a lot of different structure and strategies around getting off a month to month if you want to keep that tenant in place. Like in this case, it sounds like they might not want to, but like it's so specific on that individual. How will they communicate? What's their motivation? Are they going to mind a $20 or $40 raise per month, or are they looking to move anyways? Just it is super dependent on that tenant's personality and what their exactly what their motivation is too. So
so the only other way you can go is to terminate for one of the 5 reasons that's allowed on a periodic tenancy, and one is if you or a relative of yours is going to move in. So if that can be a possibility or a fact, then you would give them the 3 tenancy months notice for that reason. Use the right form and everything. If you're going to change the use of the building to, I don't know, a drugstore or a storage unit or something totally different from a residential tenancy. 2, if you're going to, there's 2 based whether it's going to be sold as a condominium or if it's going to be sold as a regular unit. And that's from the time that the conditions have been removed. So it'd be the month, the next tenancy month after. So it'd be if, for example, you sold it today, the 3 tenancy month notice would start at June 1st. So June, July, August, you would get end of August, you would get the possession on either of those cases. And the last one is if you're going to tear the unit down, going to demolish it. So then you can give 3 tenancy months notice. So all those are 3 tenancy months notice. And then if they go over, it's overholding, and and you go to court for that.
I'm trying to find the form. So there's the RTA, and Chris has done a really good job of explaining this. There's the RTA, which is like the legislation, the governing act, and then there is the ministerial regulation, which is basically how it defines how those rules are enforced. And the Chris says it best with his analogy is always like, so the law says speeding is illegal. Okay, we know we can't speed. But the ministerial act says if you go over 15 kilometers, it's X number of dollars. So there's a ministerial act that outlines what Don said very, very clearly. Yeah, I mean, like the only thing that I'd add into the situation too, if they refuse to sign a new term lease, if you don't want them there, try to get them onto a short fixed term, and then just don't renew and communicate that and have them move out. Or if they repeatedly don't pay well, it sounds like there's a track record here. You start the eviction process too on that. And again, we always say when you go to evict, you don't just evict on one thing they're doing wrong. You throw in all the different breaches into one eviction, because if for whatever reason you don't see eye to eye with the dispute officer, you still got a leg to stand on to get that eviction through.
And that's not all the time. Sometimes if there's other things going on and you don't want to discuss what the tenant's going to bring up. So if there's damages in the house and he wants to damages, I mean, like maybe there was a flood or something and it wasn't the tenant's fault, and but he's giving you grief and something like that. So now the tenant at the hearing, the tenant's going to bring this up and want compensation and screw things up as best he can for you using that. So if you don't bring up anything and that would give him an opening, you stick to, if the guy is, especially if the guy is 3 months behind or 2 months behind, you're talking about a good sum of money. You stick with just that one thing, because you have enough of that to get an eviction. And so this guy can rave on all he wants about how bad his living conditions are. The judge will tell him you need to file your own, and we'll look at it at that time.
So Don,
strategy.
You've brought up a good point. Why, if this is your first time as a landlord, to hire an eviction expert, because you guys understand. You probably can look at the evidence and say, you know what, I've got enough here to file on the late rents alone to get this person out, or you know what, this isn't strong enough. We can layer in these other breaches as well, and this is the best. Having your guys' guidance is so critical to make these decisions, because if we have seen, unfortunately, time and time again, where someone's gone through, it either wasn't structured properly, they didn't maybe speak the case properly, use the right wording, and it got tossed, it got delayed, and now they're back going through the eviction process again. And like you just said at the beginning of the show, we're booking a month out right now, roughly, to get your hearing. You just lost another $1,500, $2,000 in rent, again, if it takes longer and longer and longer, that can really start to stack up. So always recommend talking to folks like Don, Don Gray with Edmonton Eviction Services. As a bit of a plug for you, Don, because you guys do really good work. Again, do appreciate you guys hopping on and helping us out on the show.
And Rob down in the center there, he does a good job.
Yeah, and Rob Bull as well. Red Deer Recoveries is down in Red Deer, and just you guys are powerful and so useful with the knowledge. So, okay. Let's take on this question here. I have learned to always get a mailing address for at least one of the references. Oh, interesting. So if I need to get something to them, I can send it care of the reference. Once signed for it, it's considered delivered. Oh,
I like that.
That is a phenomenal tip. Well done. And that was Sharon. So awesome.
Good job.
Well done. That's a guy. I'm gonna write that one down because I didn't even think of that. I like that. See, this show. You get a lot of talking around the table, talking shop talk, and I'm always picking up a little tidbit to get better and better. Okay, they're saying here. Sorry, I meant he was in a 6-month lease and refused to sign a new 3-month lease. Okay.
Well, then he's gone. That just ended. Especially if he's not a very good payer. Just say, okay, no, you don't want to sign a new lease, then it's terminated, and I expect to do the move out inspection on end of the month. Period. don't let this opportunity go by, because you go into a month to month periodic crap, and you'll have him for 20 years and you pull all your hair out.
Okay, let's wrap up with one more question here. Stefan wrote, well, what is the best way to determine the value of abandoned belongings of an evicted tenant? That's
the value is today's value, not what it was purchased at. So you can look on Kijiji what are things selling for. If you see some flyers for auction sales, somebody that goes to auction sales, and because those are the kind of prices you're getting. You need to remember that bedding and couches, beds, mattresses, that sort of thing, have zero value, because most people are scared of bed bugs. And that's where often you get them from. You take a used mattress in, and all of a sudden you've got extra guests that aren't paying rent. And so they have no value out in the marketplace. So you take those off. If something is really good, 80-inch surround sound, 15 speakers and system, it's $5,000 when they bought it. It's now worth $1,500, 6 months later. And so that's the kind of thing it's got to be awfully big and expensive. I had a lady that had 2 kayaks, brand new kayaks, and she had
that'd be pretty coin.
Yeah,
probably.
She had a bow and arrow, or like a hunting bow and arrow thing, and just those items alone, we knew we're over $2,000. So the owner stored them in the unit. He didn't rent it out or anything.
Good to know. Awesome. Yeah. So takeaway there, Don, is today's value. Can you look on Facebook Marketplace, the Kijiji, Craigslist, whatever online to get a comparable secondhand value of that item? If it's over $2,000, you have to store. I would, if I had abandoned goods, I would be taking my phone. I'd be taking pictures of everything. And what I would probably do is have a sticky note or a pad of paper, and I'd write numbers and put number 1. And then here's a pile of clothes, whatever. I just document everything, because then it shows you when you go to the judge, even though the stuff doesn't have any value, that you've taken the time to collect and do a nice catalog or a database of what's left over, or a good list with numbers in the pictures, or you can Photoshop the pictures later and add a number on top of the picture. But a really easy way to correlate the stuff, and then you could say no value, no value, no value. Oh, kayaks, that's $2,000 for $1,000 for each kayak, and all that stuff. So yeah,
and that's what you need to do if it's over. I had a tenant that was so convinced that they were being evicted, and it's going to get overturned and everything's going to change for them, that they refused to pick up their stuff. Now we're talking a 3-4 bedroom house full of good stuff, 2 vehicles in the garage, and another one sitting on the side. So we're talking, I think the total came somewhere around $80,000 or $90,000 worth of stuff they had after they got it all counted. It took them almost a month to get everything sorted, and it ended up that the landlord, after some time, was able to sell all of those items. They didn't get anything back. He was able to sell all of those items, and he recouped about 75% of his costs up to that point. And his costs just escalated with lawyers and what have you.
Oh yeah. Absolutely.
Yeah.
Well, I think we should wrap it up. We are at 9:00 here. There might be playoff games in the background that I might want to go check out. But hey, go Flames, go! We're up 1-0. Edmonton's in the thick of it right now. I'm going to probably go watch and see how they're doing. But Don, as always, thanks for joining us tonight. It was a fun show. Well, we've got 2 more of these cases lined up. So Don, I'm going to probably get you to come back here. I'm not sure. Maybe we'll do one in June or something, or in a few weeks time to
whatever
spread
works
them out. Yeah, it was really beneficial. So folks, appreciate you guys coming out. I love having Don on the show because, and again, I picked up some stuff here that I did not know. I like that tip by I hope I'm saying her name right, Sharon, that about care reference to that previous tenant. That is such a lovely tip. I love it so much. So yeah, folks, enjoy. We're in May now. May the 4th be with you, because I'm that cool. So take care. Have a good night, folks, and we'll catch you on the next one. Thanks for being with us.
Thank you very kindly. I appreciate it.